What I'd like to do is take a short recess, 15 minutes, well, until 10:45, and then begin talking about jury instructions. But, well, I think before that we better clear up the sidebars. There was an objection 957 with the rebuttal witness, Detective Ryan Prock. The defense was objecting to the content of the text message that John Hansen had sent to Alexander Woodworth on March 5th or 6th, 2018. Court sustained the objection as it relates to the content on hearsay grounds. Anything else that either counsel would like to put on the record with respect to that?
No, Judge.
No, the only thing I'd say, Your Honor, is just that the state had not intended to prove the truth of the matter asserted. I understand the court's ruling that it would have been for that, and so that's fine.
All right. And then 1014, Julia Post was on the stand. Ms. Nodoff objected to an area of cross-examination that Mr. Nelson had. We had a sidebar, and I overruled the objection and allowed Mr. Nelson to continue his cross-examination. Anything else either counsel would like to put on the record with respect to that sidebar?
Just the basis was, I believed it was exceeding the scope of direct, so.
Okay. It. All right, and then again, it was, Mr. Nelson had pointed out in a report the direction he was going to go, and the court was, and he did go there, and the court believes that that would have been fair for bias questioning.
Yes, sorry.
All right, now, the defense was going to have a proposed packet of instructions.
Yes, Judge. I'm not sure where we're at, but I think we may need more than 15 minutes. Obviously, there's been a lot of balls in the air here, and so we're close to that. I would ask that maybe we take a break until. Hold on a second.
Well, here's what I'm thinking.
So we have.
We need your microphone on too.
I think we can get you something by 11 o'clock.
Okay.
So.
All right. Well, I guess then it's not going to be productive if we come back in 15 minutes. So, but I have a starting point packet, and that includes what was requested by the state. In addition to, and this is what I would like you to think about between now and 11 o'clock, is that I did my own relatively short instruction on how the jury can use the psychological evidence. Now, it's interesting in reading the, I think it was the Morgan case where we're talking about, they referred to this in Wisconsin. The history of Wisconsin law is mind science in the guilt phase of a trial. But I don't think we had any psychiatrists. We had psychologists testify. But in any event, and I'll certainly share that with you, but I want counsel for the defense in particular to, I guess be ready to articulate and argue as to what purposes the jury may be able to use that evidence. I was wondering whether the defense, in part, was intending to argue that the evidence, psychological evidence, was in some way circumstantial evidence that there had been an attack. And again, I don't know, but I'll give you, again, my idea, certainly, but I think it's very important that the jury be advised that, again, this is not an insanity case and that they're not to consider any of the psychological evidence for purposes on the ultimate issue of guilt or not guilt. And that it doesn't go to intent, certainly. That's not part of my instruction. But it can be used, well, I'll just give you my instruction, but I want you to think about that because I think the jury has to be told how they can use that evidence. And it's, there's quite a few cases, but I also believe that it supports the court's opinion, at least in what I read in the Morgan case, it supports the court's opinion that evidence of psychological evidence can be relevant and can be used for the jury when considering, again, for example, the reasonableness of either the belief that she was in imminent danger of death or great bodily harm, or whether the amount of force used was reasonable. But I don't know of any case exactly on point with respect to that. But I want you to think about those aspects, because I think there probably would be a considerable amount of discussion about that. So then we'll break until 11. Does that give the state enough time?
Sure, that's fine.
Judge, if we can just quickly clean up Exhibit 720 so we put that issue to
Oh,
bed.
yes.
That was the portion of the DSM-5. There was an objection and then a sidebar, and the court allowed admission, and then there was some additional argument afterward. And rather than continue with the argument, the parties worked together to come to an agreement as to which portion could be used as substantive evidence. It's partial page 274 through partial 276 with some exceptions. I will have, the state will work to get a redacted version of this, and then we will provide that to the clerk when we come back.
All right.
I just think Attorney Nelson, I've discussed it. I don't think the defense has acknowledged that there was that understanding, so I think there just need to be a record.
Is that correct, Mr. Nelson?
Acknowledged, yes.
Okay, very good. All right then, we'll be in recess until 11 a.m.
Thank you.
All right, we're back on the record. It's a little after 11 a.m. Okay, counsel, I believe that the court provided parties with, I think, 5 copies of a preliminary packet of instructions. And I think the thing, here's what we have to do. The court reporter needs a few hours in order to complete the transcript requests that have been requested. And so if we address some issues now and then break for a period of time and then come back, that might accommodate that so she can get that done for you. So the first thing I'd like to take up is the issue of lesser included offenses that would be submitted to the jury. And the state, well, actually, that's the second issue. The first issue I want to take up is, notice on the information that the penalty enhancer using a dangerous weapon was used. It was alleged. It seems to me that, and we don't have it on the proposed verdict forms, but it seems to me that would be a special jury question.
It is, Your Honor, and it should be on each, depending on whether or not the court gives any lesser, well, court is, I suspect is definitely going to give at least one lesser included, which is second degree intentional. We can talk about the others in a little bit, but yes, it should be on each one. And that would be a question that will say if you find the defendant guilty, then answer the following question. And it would, did the defendant use a dangerous weapon in the commission of the offense? Yes or no?
All right. And Mr. Nelson, does the defense have a position on that?
A lot of moving parts right now. I was not listening as well as I should.
Okay. Well, just to sum it up, and I think the state concurs with the court that there should be a special verdict question on any guilty verdict forms for any offenses submitted to the jury, that if you find the defendant guilty, did she use a dangerous weapon?
Yes, I understand the charging. I understand that's how it would be handled. I'm not in a position to comment on the wording of it, but in principle, I understand, and I think that's the correct legal way to handle it.
Okay, so we just have to make a note, Mr. Dietrich, we have to put that on the verdict forms. Okay. First of all, now moving second, I guess, into lesser included second degree intentional homicide. In the court's opinion, it's appropriate to give that. I mean, the analysis is it a lesser included offense? Yes, it is. Number two, is there a reasonable basis in the evidence, looking at the evidence in the light most favorable to the defendant, a basis to acquit on the greater degree. Again, if the jury, looking at the light, in the light most favorable to Ms. McCandless, the court believes that a second degree intentional homicide would be a lesser included offense. It should be submitted to the jury. And I don't know if either party wants to argue that or disagrees with the court on that.
I think we'll eventually, I think probably the best thing now, Judge, is to just, if you have some preliminary rulings, I know we have a memo that we're submitting now about lesser included. We're e-filing it in the moment. I don't know if now is when you want arguments on all of these. I think what would be most helpful for the defense is if Your Honor has some of these preliminary, to just put them down, and then we can come back and say what we agree and what we don't agree with once we know kind of the bigger package.
That's what I would like to do, because if nobody disputes that as a lesser included, then we don't need to spend a whole lot of time.
I don't believe anyone's disputing second degree intentional as a lesser included. That should be
You agree?
No, Your Honor, we agree that there is evidence that would support a
Okay. All right, so that's not disputed. Now, the state has withdrawn its request for a first-degree reckless homicide, and the defense has requested that, as well as second-degree reckless homicide and homicide by negligent handling of a dangerous weapon. So who is going to handle that on the defense? Okay.
Ms. Vichny will, I know she submitted some writing, and is now the time we want to argue that, or do we want to? I thought we were just going to defer to Ms.
Well, I would like to get some things out of the way, because they were going to. And here, I just want to address that, Ms. Vichny, you had mentioned, I think it was off the record, that most cases, and I would tend to agree with you, most cases that I've been involved with, and I recall one homicide where there was, we had I wasn't the judge. We had I think a 4-hour instruction conference in chambers, and, I went away from that thinking it shouldn't be done that way. We had a whole courtroom full of people waiting, and frankly, it was a case that was tried like 2 weeks after State versus Deborah Head came out, which turned the whole law, frankly, well, I don't want to use a pun there, but
Deborah Head overruled Camacho.
Yes, and so that's where, it was a pretty significant case when there was arguments about self-defense. So it was, frankly, my experience from that is I'd like to do as much on the record as possible, because otherwise we're just going to be repeating a whole lot of things. If we can do some off the record here in the courtroom, give the court reporter a break if there are things that we agree on. But what I would like to do is go through and again see what's disputed here, and then I guess we can come back and argue it. But it's disputed as to the three lesser included offenses the defense is requesting that the state is opposed to. So do you want to take that up now, or do you want to take that up?
Well, I have done a written memo,
Okay.
which cites a lot of case law,
Okay.
though it's all Wisconsin case law, because I think that's what's pertinent here, except for one U.S. Supreme Court case. I would like the court and counsel to read my memorandum before I argue it, because, that was the purpose of putting it in writing. I don't know if the clerk has received the e-filing yet. Our final version of it was sent to Mr. Nelson's office at least 15 minutes ago. Madam Clerk, have you received it?
I won't receive it, it would be a different clerk.
Oh, okay,
I haven't received it, so I don't know that it's been.
I
Well-
did not see it in the.
okay. So, we can certainly, though we've e-filed it, I can certainly print a copy for everybody. Right now, it just won't have the formality of signature lines and the proper header, but
Sure.
the body of it is exactly the same. Would you like us to do that, Judge?
Yes.
Okay. Mr. Maxey, could you please print out and with a copy for the court and a copy for the prosecution?
Okay, moving on then, so obviously we'll come back and we'll argue that then after the lunch break. We're going to take a longer lunch break today. Some water.
The other thing, Judge, I know, I'm sorry, Mr. DeFore, did you submit your proposed McMorris instruction?
Yes.
Okay. We're also in the process of e-filing an alternative to the state's McMorris instruction. They're similar, but they have different language. Do you want us to go get a copy of that printed as well?
Yes.
Okay, we will do that. Mr. Nelson's going to go tell that to Mr. Maxey. The other thing that we are e-filing, there were a few pattern instructions that we didn't see in the court's list that, you know, I don't know if it was inadvertent, but just so you know what we're e-filing. We didn't see 155, which is exhibits. And if we overlooked it, I apologize to the court. But Mr. Nelson advised he didn't see 155. He didn't see 157, remarks of counsel. He didn't see, we didn't think there was 160, closing arguments. Or 190, weight of evidence.
Weight of evidence is on page 17 for sure.
Okay, that could be, Mr. Nelson read this, not me, so I can't say what's on what
Right.
page.
16 has remarks of counsel 157 and exhibits 155.
Okay, that could be, I mean, we went through this very quickly.
Right.
So we were going to e-file additional ones, if they're already in
And
there.
closing arguments is on page 20, counsel.
Okay, that's fine. So if those are in there, I apologize to the court and counsel.
Yeah, those are all included.
Okay, that's fine. We just made mistakes as we were going through the packet. So the other thing that we are e-filing is the proposed substantive jury instruction. And that has not, or that should be e-filed. If you want a hard copy, we can again ask Mr. Maxey to produce that. The other thing I wish to advise the court is the court's instruction, other acts modified, 275. We want to take a look at that and potentially make some changes to it. We just haven't had time to really think about that. I mean, I think our version will have similarities to what the court did, but perhaps some crucial differences as well, too. You know, I'm not sure, we haven't really talked about it. What? Okay. Well, the other thing that he wants a hard copy of is our substantive?
Yep, he's working it off right now.
Okay, that's good.
And this is, these are, okay.
Judge, that was the, apologies for interrupting, that was the one is the McMorris, defense version of McMorris, which is entitled the cautionary instruction, and the multiple page document is Ms. Vishny's memorandum of law, which anticipates, the first sentence anticipates the substantive instruction, which is being printed off right now.
Then and we probably don't need to file the requested jury instructions because we were wrong. We missed 155, 157, 160, and 190. So.
Yeah, 160 actually lists 460.
460?
Yeah, but it's on,
sorry.
what, page 20?
Okay, that's fine, but while you were out of the room, it was determined that we had missed 155, 157, 460, and 190, that they're all in the court's submissions.
Great.
So I think we could tell the office to not file this, and that we need to work on 275. So we could probably, you know, I don't know how long it'll take me to do that. That's a rather...
I have my scribbles, so we have, I think, minor edits to the state, to the judge's proposed one.
Okay, but we need to retype it, so, yeah, we should retype this.
Okay, well,
I don't know if you want me to do that after lunch or
You know,
before lunch. I could get this typed up in about 15 minutes. I'm not that.
yeah, well, that's what I thought. We would break for a period of time. Again, the court reporter needs time to work on those transcripts.
Right.
So,
Just tell me when you want this.
you know, if you were to email it, if you typed it and emailed it to Mr. Dietrich, that would be fine. We can print it out.
Yeah, I think he must be in my email now because I emailed something yesterday, right? I'm sorry, what was the first name of that person again?
Joseph.
Okay, let me just, it's right. It's right where? In my email?
He's right there.
Oh. I'm so sorry, because we hadn't met personally, I don't think. Okay, but let me just see if it would be Dietrich. D-I-T. I'm sorry, Mr. Dietrich, what's your email? D-E-T?
We can go off the record for.
Oh, Joseph Dot. I'll email that to him as soon as I've finished it, and I'll go work on it right now before lunch. So do you want us to reconvene before lunch?
No, I want to give the court reporter an opportunity to, look
Sure,
at his transcripts. And I want to know, what we can agree on and, what's disputed. And so I can study those differences and come back for the formal conference then.
I think we'll also submit a revised version of what I think Your Honor's calling the mind science instruction.
Well, I made that in brackets. I took that from Morgan because of the use of the term mind science in quotations in that case, but
Just
I think
whatever we call it, just
I think it should
talking
be-
about the same thing.
I'm thinking it should be called psychological evidence.
I do too. That's rather passé, mind science. Cases
Well, I think psychological evidence is more appropriate
Right.
for
And
instance.
we would agree, Your Honor.
Okay,
All right, so then we're going to so both of these really, one is 275/605 and the other is just a pure 275. And we're going to enter revised submissions to both of these. We appreciate the fact that the court has done some work on these, really
Well, it's a
making
starting
our
point.
path easier.
yeah, it's just a starting point.
Okay, so we'll retype this and get that. So what time, Judge, would you like us back here?
Well, let's work through this. I want to know let's figure out what we have. And then
Oh, we
let's
have more
talk
to
about
do.
that.
I'm sorry, I didn't realize that.
Well, okay, you mentioned a different in substantive instructions. Was there something about the substantive instructions that?
Well,
Apologize, I just handed our substantive instruction to Joseph.
How does it differ from the pattern instruction? Is that significant?
The insertion of self-defense in different places, and obviously the lesser included. The biggest difference is all 5 of the homicide charges, as opposed
Okay,
to
I see.
the instruction that right now only, I think, has 3. I don't know what the basis is, other than just, that was the state's original submission for first degree, second
Yes.
degree, first degree reckless.
Yeah, that's the starting point for us.
And so we have in ours, the language that we talked about before, use of the word woman rather than person. We have all 5 homicide counts, and we have, I think, the appropriate use of self-defense based upon the Austin case for the reckless matters. And I apologize, I don't have the Austin case at the top of my head, but it's mentioned in the footnotes.
Are you talking about force less than that likely to cause death or great bodily harm?
Hold on just a second, Judge.
.801 instead of .805.
no, the Austin case,
Is that in your memorandum?
no.
So the Austin case, I apologize, State v. Austin, AUSTIN, 349, Wisconsin 2nd, 744. The open site, 213, Wisconsin Appellate 96. That was regarding self-defense in reckless crimes. was a modification to the standard jury instructions, I believe, in 2015. What the jury instruction committee said, modified it based on Austin. The defense thinks that it did not follow Austin completely, and that's you need to read Austin, is the bottom line.
All right.
Yeah, so that's not in the memorandum because the memorandum only really deals with the issue of reckless, the 2 degrees of reckless and negligent homicide and lessers in general. So this has to do with the way that the language is drafted on self-defense to every single degree.
All right. Well, I'm going to just address the issue about the self-defense, the wording of that right now. I'm going to stick with a reasonable person. I think that's correct in the law. I've had a chance to think about it overnight. It's a neutral pronoun. I think is very appropriate. And looking at it from the circumstances of the defendant, certainly you can argue, that's one circumstance. She's a woman. But I just think a gender neutral pronoun in that's what the pattern instruction is. And I just think that's the correct way to instruct the jury on that, just so to put that to rest. I heard arguments about that yesterday, and so that's going to be that way.
Okay, 1 minute, Your Honor. So do we have a backup? Okay. So what we have, so we're going to go, can you go back? Let's tell, all right. So we're still e-filing for purposes of record preservation, that jury instruction, so that's preserved. But we have a backup version that uses the gender neutral, but still with the lessers and the self-defense language that we are asking for. So Mr. Maxey is going and getting a copy of that now, so then the court can look at that without having to think about, I need to change this gender language.
Okay.
I think I'll just make it easier.
All right, thank you.
Well, Your Honor, I guess the state's position is that, the law and the instruction says that they are to take, that it's the reasonable person in the defendant's situation. It already clearly makes that case that does it. You don't have to change it to a reasonable woman. I think, frankly, it's inappropriate to do that. I don't think there's a basis for doing that. And I think that sticking with the standard and jury instruction is the way it should be, and it already, as I say, takes it into account.
Okay, and so that's a decided issue then. Okay, so as far as the substantive instructions, it's just, again, it's not the substantive instructions themselves, it's just whether they're included, and then a different self-defense instruction for the reckless lesser included than for the intentional crime and lesser included. Is that correct, Ms. Fishney? Is that the difference?
I'm sorry.
In terms of the elements of the offense, you don't disagree on that? Okay.
Yeah, it's going to be identical, but it's going to use the pattern gender neutral language.
You were correct, Your Honor. The issue that we're contesting is when and how many times does the self-defense definition get inserted and where within that as well. I believe the pattern instruction on reckless, if Your Honor gives reckless, the pattern instruction does not have self-defense as a separate element. The pattern instruction has self-defense as a part of the assessment regarding criminal recklessness. And it's the defense's position that Austin actually says that just like under intentional, when it's reckless, self-defense needs to be consideration not only in the assessment of recklessness definition, but it's a separate element in and of itself. And so that's the distinction in our instructions from the pattern instruction.
Okay.
So I just didn't want to say that we were agreeing that they're the elements, because that's really what it comes down to is self-defense an element of recklessness, or is it considered in some other way?
And Mr. Dufour, I mean, for sake of argument, that court were to give the lesser included instructions on the reckless homicides.
Yes, and the court, if the court does decide to give the lesser included, it's right in the instruction that you've prepared. It says the defendant is guilty of first-degree reckless homicide, et cetera, et cetera. You will be asked to consider whether the privilege of self-defense, in deciding whether the elements of first-degree reckless homicide are present. You don't have to give the instruction and shouldn't give the instruction on self-defense multiple times. It gives it inordinate emphasis if you give it multiple times, and there's no reason to give it multiple times. It's already in there, and if the court gives additional lesser includeds, you can add additional lesser includeds to that instruction, which starts on page 3 and ends right now at the top of page 4. You can just add on another bullet point after that one if you give second-degree reckless, another bullet point after that if you give homicide by negligent use of a dangerous weapon. It's, there's no reason to give the whole instruction on self-defense more than one time.
Yeah, I'm not trying to rebut. I understand that position. We disagree, but I understand his position. On page 9 of Your Honor's submitted instruction regarding first-degree intentional, it talks about, first-degree reckless. It lists the elements of the crime, and it lists 3 elements: cause of death, death by criminal or reckless conduct, and number 3, utter disregard for human life. And it's our position that there needs to be a 4th element, and that is while not acting in self-defense. Just like there's an element for that in the intentional, it's an actual element as opposed to a consideration under reckless. I understand they're going to oppose that, but I just wanted to make clear what our position was.
Okay, good, thank you. And we'll take that up again when we reconvene after I read the Austin case. Okay. Now, I'd like to just go through this briefly. We talk about now the substantive instructions and lesser includeds and self-defense. On burden of proof, presumption of innocence, I know there was a pretrial motion on that, 140. I have been giving, I'm sorry, the version that we have in this draft, which sort of a compromise. It comes from I think the jury instruction, it comes from a footnote, and I guess I'd like you to weigh in on that, but rather than the last sentence, I change it to, you are to search for the truth and give the defendant the benefit of a reasonable doubt if it arises in your minds after you have carefully considered all the evidence in the case.
Just from the defense perspective, Your Honor, we filed written arguments about this, I believe, with a brief. I understand Your Honor's ruling. I stand by our position, but I don't know that the defense is requesting to be heard on it anymore.
Okay.
And while the state would prefer the standard draft, we understand the court's position and understand its court's discretion.
Okay, and so I'm going to give it the way it is here. I think that's a fair compromise. And there had been a fairly recent case, I think, that really upheld the standard instruction 140, but the court does have some discretion there, and I think this strikes a fair balance. Okay, any dispute with 145?
No, Your Honor.
What about 103, the pattern instruction? I think we have to add in there judicially noticed facts.
Nothing on 103, Your Honor.
And but you agree we should add 4th facts?
I think that's actually covered in 3rd. It says any facts to which the courts or lawyers have agreed or stipulated or which the court has directed you to find.
Very good. You agree with that, Mr. Nelson?
I apologize. I was handing clerk,
That
the neutral.
the pattern 103 would include judicially noticed facts, the way that it's
What
drafted.
page are you on?
That's page 12 of the court's packet. Okay. All right, and then with 275, there are a few different variations in the court's variations. We already kind of covered that. Now we have the submissions from both parties, so we'll study those, and then we'll take up argument on that when we reconvene.
You don't have the R2, oh,
I think, it's-
McMorris stuff, you mean?
I don't know
Yes.
what was just handed to me, if that was a copy.
I think we called it, hold on, yeah, cautionary instruction, evidence of prior writings of the victim. That's what we call it. But right now I'm working on the courts too.
Yeah, I have your copy of that. Yeah.
Okay, I just wanted to clarify that we're still working on those.
Okay, yeah, and that's, again, that's what we're gonna have to reconvene, we'll take that up. Mix those up. Okay, so moving past that, 170,
Judge, we are going to be asking for 172 in addition to 170.
What's that?
172 is evidence of conduct. It basically reads something to the effect of evidence has been received as it relates to the conduct of the defendant after the incident, whether that evidence shows consciousness of guilt, and to what extent consciousness of guilt indicates actual guilt is for you, the jury, to decide. That's pretty close. I don't think it's an exact quote, but it's pretty close to what it says.
okay,
We object to that.
okay.
I believe there's clearly been evidence of attempts of the defendant to conceal, concluding her statements to people that the incident happened at Owen Park, including her request to go to the hospital and not to have the police, and not a request to have the police called. You know, I think all of which are evidence of actions of the defendant and evidence that she lied afterwards. In fact, I think admissions that she lied afterwards about certain things, such as who carved boy into her arm, all of which is evidence of conduct that can be argued as consciousness of guilt, Your Honor.
Okay, again, we'll take that up when we reconvene. 157 and 150, well, 157, first of all, any objection to that? It's pattern instruction.
Okay.
155, exhibits?
No objection.
Okay.
Objections of counsel, 148?
No objection.
No objection.
147, improper questions?
No objection.
No objection.
150, stricken testimony, there actually was.
Yeah, there was some, so no objection.
No objection.
And weight of evidence, 190?
No objection.
No objection.
195?
No objection.
No objection.
And 300, credibility of witnesses, and we do have it, the draft with the defendant has testified in this case.
Agreed.
And no objection. And I assume that portion about the defendant testifying, I believe, has to come in at the defense's request, but I assume they are, and it's no objection.
Okay. All right, and 200, extra expert opinion?
No objection.
No objection.
Expert testimony, hypothetical questions. There was hypothetical questions asked by Mr. Hahn.
Yeah, I think there were some, so I
Yep.
think,
Any objection to that?
I don't recall the hypothetical question, but that's the standard instruction if there was one, so.
Okay. And then we'll just take out the shaded and bracketed portion, who requested it. So then 205, then okay there. Impeachment of witness.
there was testimony as to Mr. Stoiding having been convicted of a crime, so it would be, I think that was the only one.
Okay, so again, we remove the bracketed and shaded language, and then it would be evidence has been received that one of the witnesses, he's the only one, in this trial, has been convicted of crimes. And then, so we remove the rest of the shaded language there, adjudicated delinquent, we don't have that. Take out the brackets, but it would be convicted of crimes, I think it was 24, something like that. And then, so, both parties okay then with that?
Yes, Your Honor.
Okay. Okay,
We're withdrawing 327, Your Honor.
327 will be out, there's no evidence of prior. Okay, 160, okay, I misread it, it was 160, not 460. 460 was right next to it.
Agreed.
Yes.
So that one is okay. Closing instruction. And of course, 482 will depend upon, what the decision will be with respect to
Is there
lesser.
a longer version of 460 if I was? I'd have to look it up here, sorry, Judge.
Well, just make a note of it, I just assume that,
No,
Right.
that's a full 460 as far as I recall it.
I think this is the straight pattern instruction for 460.
I agree that that is the straight pattern instruction for 460. I thought that there was another number that's an alternative to 460 in my possession. But I will have to look it up and get back.
Okay, then we'll hold off on 482. What about 515? Everybody
No
okay with that?
objection.
Okay.
Agreed.
And 525A, I don't know that that's all after anyway. So then the verdict forms and all of that, that will be dependent upon lessers as well as, but they will include for any guilty verdicts for substantive offenses, will have the question, if you find the defendant guilty, do you find that she used a dangerous weapon, yes or no?
Now, there should also be an instruction on use of a dangerous weapon, Your Honor. I'm not sure on the number on it, but we'll find that
Okay.
and advise the court as quickly as we can.
Okay, so any other areas that we need to address when we reconvene?
No, Your Honor. Outside of, as I said, the use of a dangerous weapon and as to the 172, nothing else.
Okay. And has the state had an opportunity to review well, I should put it a different way. Is there anything in addition the state would like to submit with respect to the 275 and the use of the psychological evidence?
No, Your Honor, I think what I saw on here, and I have it, well, I put it to the side, but now I don't see it to the side. I think the way the court did it is fine from the state's perspective.
Mr. Nelson?
We
Or Ms.
disagree.
Vishnu.
We disagree. We'll be submitting, is this the 275 panorama evidence, or is this the 275 psychological evidence? But
This is well, it's not really, it's just, I just drafted it.
we're submitting revised versions of the jury instruction regarding the journals, revised vision of the jury instruction regarding panorama evidence, and a revised jury instruction regarding psychological evidence. So we will be submitting in writing those defense proposed versions of those three
Okay,
instructions.
and you do that, when will you have that?
Well, the panorama one, I've been typing while sitting here, it's just about done,
Okay,
really. We could probably,
think we can do them both. I think the other one has other minor changes, so 20 minutes after we're out of court?
Sure.
It's mostly a question of how long it takes me to type. It's much more that. That's what's taking the time, quite frankly.
Okay.
And Your Honor, the instruction on use of a dangerous weapon is 990.
990, got
Yes.
that, Joseph?
So this was charged with.
Mr. Dietrich.
I didn't know that. So that's in our jury instruction.
All right, then, we'll go off the record for a moment. Madam Reporter, how much? Sorry about that. All right, we are back on the record.
Judge, for the court and everybody's aware, I have good news that, if for some reason jury deliberations go into next week, my trial in Iron County, a plea was entered today.
Well, good, all right.
But hopefully they don't go into next week, so we have to worry about that.
Here, I thought the good news was going to be that we actually agreed on a difference in a jury instruction.
We've agreed on some things,
We
Judge.
have agreed on some things, so.
We were hoping you agreed on the jury instructions.
Well, we can at least tell you that as to the, hold on a minute, Go ahead. You have to press on it for a while, there. We can at least advise you, Your Honor, that we have agreed on the instruction that is called, it has cautionary, one minute. It's called the cautionary instruction, evidence of prior writings.
The version that you proposed?
The version that we proposed is agreed to by the state.
Yes.
So that would be fine. I'm assuming the title of the instructions, you don't read them, you just read the body of the instruction, correct?
Yes, I
Okay,
usually leave the titles in there just for being able to, particularly for instruction conference, but if counsel.
For the conference, yes. For the copy that goes to the, jury, I want it called Prior Writings of Alex Woodworth, not Victim.
I think that's what we have in the version that you should have from us.
Oh,
Wait,
okay.
no, I'm sorry.
Yeah, it says Victim. I just think it should have his name, Alexander Woodworth. But otherwise, the defense copy has been agreed to by the state. So we don't have to fight about that.
Yes.
Joy, did you see that?
I don't think that one's in there, I think we only have the one by the state, so we'll have to add that one on the next draft.
Okay, so the one that the defendant proposed, we'll put in there, because I think I did.
Did we
I think we
e-file?
were just trying to get it done fast and missed
I
it.
think it did get filed.
Okay, just want to make sure we
leave
leave. All right, so I would ask for that one modification that it be, that in the packet, that it say of Alexander Woodworth.
Okay, so do you have any objection to the bold capital letters in between, like,
No,
would say evidence of prior writings of.
no, I don't care about that.
Okay, so we'll replace what we have here. It'll be cautionary instruction, this is on page 16, cautionary instruction, evidence of prior writings of Alexander Woodworth. And then it will be what is.
The defense version.
Defense.
Okay, thank you. The next one, which is the panorama evidence instruction. The defense submission has an error, which it failed to incorporate the last paragraph that the court had drafted, where it says definitions on the issue. It's two paragraphs. It's the evidence was received on the issue of context or background.
Right.
I think that the state has no disagreement with the defense revision of that instruction and the omission by the state. What?
Right, Your Honor, we had no problems, and I think the court did that already. The court changed that in what it submitted to the sexual encounter between Ezra McCandless and John Hanson. But the end of what the court had originally submitted, which states definitions, and then the evidence was received on the issue of context or background, that is to provide a more complete presentation of the evidence relating to the offense charged. The next paragraph, you may consider this evidence only for the purpose, it probably should be purposes I have described, giving it the weight you determine it deserves. It is not to be used to conclude that the defendant is a bad person and for that reason is guilty of the offense charged. That language should be included still, and I believe counsel is agreeable to that.
Well, take a look at ours on page 15 and going into 16. Does that have to be changed then?
Yes, we've changed it. Hold on a second. Yours,
Because I thought we put
where
in
is
there.
it? Hold on a minute. Is this a new copy?
The last two paragraphs that you had, so we can just reinsert the paragraphs you had.
Okay.
One second, because we did make some changes. So wait, this is prior writings. This is not prior writings, we're not that. Oh. Okay, page 15 going into 16. Okay, so, all right, so we changed alleged sexual assault into sexual encounter. The parties agree with that. Let me just look at the other. With respect to the offense charged in this case, but I also like the last sentence that was in the original court's version, and I think we should have it, which is, it should not be used to conclude that it says the defendant, I would ask it to say Ezra McCandless, is a bad person and for that reason is guilty of the offense charged. I would like that last sentence in there.
All right.
I just think if the court just puts back the paragraphs it had under definitions, that properly states the law, and just have that whole section in there. That's the way we would request it, and I think that states the law. It conforms to the pattern instruction on it, and that's what our request would be.
I'm agreeing with you. I just would like the word Ezra McCandless instead of defendant there because we've used her name throughout that, and I do feel her name should be used throughout this because we're.
Okay, in this instruction, but not necessarily the whole packet. That may be an issue, but.
No, I'm talking about this particular instruction. We can get to that later on other ones, but this is full of people's names, so I think she should be just treated the same as all the other names that are in there. I understand that.
Yes.
Yes,
That's what we
okay.
want. So we insert the last.
Okay, that's good. So that one we're resolved. All right,
Okay,
then. Okay, then the next one, the court's copy is on page 17. The mental condition. I don't know in your latest copy if you adopted ours or not.
Yeah, it's changed in that instruction.
yeah, we put both of your versions in there, and I'm fine with how you've changed the court's version. I'm fine with the defense submission as a statement of the objection.
I prefer the court's original version, Your Honor. I think it better states the law, and would ask the court to do that, but change from, first, this is not an insanity case, to this is a mental responsibility case. But otherwise, I think it more accurately states the law and more completely states the law than the version requested by the defendant.
So I don't agree with that. We've added these words. However, Ezra McCandless is not raising such a defense. I think that that's important and makes it very clear that the defense has not done that. All right, so that line.
Yeah, I'm fine with that line. but
Okay.
What is it that,
I think-
Mr. Dufour, that you believe that should be in there that isn't in the
I'm trying to
modification?
find, and
You're probably talking about paragraph point number
Court's original
1.
version, and No, I've got it here, it's just a matter of getting to the right version here. It's this one. I have too many papers here, Judge, I'm sorry.
Well, I do actually have a version that had the court's versions with strikeouts and then ours in bold. And so I can tell you exactly what the differences were, Mr. DeFore, if you will trust me to do so.
Sure, that's
In
fine.
point number 1, this is what the court wrote. You may consider the psychological evidence on the issue of whether Ezra McCandless suffered from a condition, and then the court has the word caused a lack of ability. And we changed that to presented barriers for her to encode, store, or, because we think that more, it's not really a legal issue, it's what the testimony was. And the testimony wasn't really about lack of ability, it was about presenting barriers. So we think that more properly reflects what the doctor actually testified to. And that included encode, store, or retrieve, whereas the court said a lack of ability to retrieve. So, and then the court wrote an involuntary repression or blocking of memory, and I don't think, that implies that that's being done proactively by the person repressing or blocking memory, that's something that someone's making a choice. So we changed that word to response, an involuntary response that interfered with her ability to remember. We think that more accurately reflects the testimony. It's not really a legal issue.
Any, from the state, any,
This is the original version? Okay. Let me take another look here.
Mr. DeFore, I could email you the two together.
No, that's fine.
Okay.
I don't- There it goes.
The old court's version, but the new court's version adopted ours. Right.
And I guess I don't have a problem with the modifications, that's fine.
No,
all right, then we'll leave it that way, and then we'll
that's a good one.
take out the paragraph above it on page 17.
Okay,
Yes.
Okay,
all right.
and, okay,
Then we get to, oh, you know what, ours doesn't have possession of a dangerous weapon there. And it should. Well,
okay, you want to go back to the top then? And I guess you can tell from the packet that I provided to you that I have not included the homicide by negligent handling or operation of a dangerous weapon.
okay, I'm sorry.
And let me know when you're ready. We'll go into the
Yeah,
lesser included.
I have so many papers in front of me, unfortunately, I kind of lose it when that happens.
Yeah, I totally understand.
Okay, so I need to figure out which is which. So the courts these are the new courts. I need Mr. Maxey to help me, just 1 minute, please.
I only brought one version back with me.
These are the new ones, not these? What's this one? They gave us 2 copies. Okay, so let's go to the courts and just so I understand. Okay, so what the court's inclination is, just for the very first issue, is to not give homicide by negligent handling of a dangerous weapon, but to go down to second-degree reckless homicide.
Well,
Is that what
I feel, first of all, right now, that I think it's appropriate to give first-degree reckless homicide instruction in a version that the defense submitted. With that version of self-defense, I read State versus Austin, and we have included it, make it clear that it is an element the state has to prove that it was not
Right.
lawful self-defense.
And we are not, I was not going to disagree with that, Your Honor,
Okay.
when we got to that point, so.
I think the state's disagreement is about whether it gives it at all, but
Right.
if the court's giving it, the state did not disagree with the defense use of the language.
Right.
Yeah, I mean, I think the pattern instruction does say that the burden is on the state. This just makes it more clear, puts it out there as an element. So
It does, and then the other difference that I have to look at was, and I think the parties both agree with this, is, all right, so on page 4 of the court, but where's ours? Okay, so on page 4, so let's, where the discussion occurs of self-defense. So the court's version starts on page 3.
okay.
Okay, the court's version starts on page 3. Where, okay, can you get that for me, please? Okay. Ours starts on page 2, so we have a line that the court doesn't have, which is self-defense is an issue in this case.
Right. And we agree that should be there, Your
And
Honor.
where would you?
Just under, it should be the first sentence under self-defense.
Okay,
The
like
court
a
starts,
paragraph by itself?
no, it's just a first sentence of that paragraph.
Okay, so just change the first sentence of that paragraph.
Right.
Mr. Dietrich, to
Add the first
self-defense is an issue in this
Okay.
case.
Yes.
Actually, Judge, I made a mistake. If you actually go back to page 2, we have a one-line theory of the case in ours, where we wrote, it is the defense theory, whenever the court ends with the charges it's going to give, I think it is appropriate to give a theory of the case instruction that the law is pretty clear that that theory of the case should be very brief and succinct. And so we wrote, it is the defense theory of the case that Ezra McCandless stabbed Alexander Woodworth in self-defense.
My only problem with that, Your Honor, is that that's already in there, because I understand a theory of the case instruction when it's not part of the instruction already, but it's already part of the instruction that this case is about self-defense. I don't think you need a separate theory of the case instruction when it's already, the court is already instructing that self-defense is the defense in this case.
Well, it's our position that, first of all, we want it. Second of all, we think that the law allows for it. And third of all, every trial I've ever been in, it has been right after crimes to consider. That's where all the courts have placed it. So that's the reason for it being placed there as opposed to a separate jury instruction. I think that's where it should go. If the court doesn't want it to go there, then I think it should be a separate instruction. But
So,
I think it makes a lot more sense to put it there, and I don't think it's overly obtrusive. It's one sentence that incorporates really the law with the facts. So the defense theory of the case that Ezra McCandless stabbed Alexander Woodworth in self-defense, that's it.
and where do you believe that should be inserted?
I think it should be right after crimes to consider, obviously.
Page 2?
Page 1.
Page 1.
Oh, I'm sorry, page 2 of your version, page 1 of our version.
All right.
Yes, so that's where I think it should go, right after the crimes to consider. It should be the last line of that paragraph.
So the last line of the paragraph.
Yes.
Yeah, again, I don't see any harm in doing it to the state, any prejudice to the state, so we'll do that. The theory of
It is
the defendants, or the defense theory, or
It is the
defendants?
defense theory of the case. I don't care if you say defense or defendants, it's just the way
Okay.
I wrote it.
We'll just do the defense theory of the case is that Ezra McCandless stabbed Alex Woodworth.
Yeah, we don't have the word
Self-defense.
is, just that. It is the defense theory of the case that Ezra McCandless stabbed Alexander Woodworth in self-defense. Okay, so that's, oh, boy, sorry.
Okay,
Okay,
so
all right.
Go with
Now, moving along, so this is our page, this is the court's page 3, right? Self-defense. All right, so then, as it goes, page 3, the rest of that would be the same. Page 4,
I think actually, counsel, on page 3, after the defendant is not guilty of any homicide. That paragraph, I think there should be the defendant in their request at the bottom of page 2 has language that is part of the pattern jury instruction on self-defense, and so I believe is appropriate there, which is a belief may be reasonable even though mistaken. The reasonableness of, and whether the court uses Ezra McCandless's or defendant's belief, I'll leave up to the court, must be determined from the standpoint of her at the time of her acts and not from the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of defendant or Ezra McCandless under the circumstances existing at the time of the alleged offense.
That's correct, and that's direct language from 805.
Right, I agree. I looked up 805, it does directly come from there.
Mr. Dietrich asked me specifically about that, and I thought we had that somewhere else, but we'll read it.
I looked, I didn't see it somewhere else, Your Honor. So.
Well, I didn't have in a belief may be reasonable even though mistaken. I think we took that out, so. You know which paragraph, Mr. Dietrich?
If it's, I didn't see it somewhere else, but if it is somewhere else, then that's fine, but if it's not somewhere else, then it should be in there.
Okay, we can give it to you if you need it later. I mean, we have it on our copy. Okay.
Yeah, we have it. We just,
Right.
you have to retype it. Okay. And you want that, you believe that should be in the area of
Yes.
self-defense?
We think it should be there.
Okay, so we'll put that in,
Okay.
between, the,
Not guilty.
perfect self-defense and the,
And then starting to get into the different degrees. Now,
okay.
the
it's all on
next,
page 3.
okay, then the next one, okay, your next bullet point and ours are the same. The first degree intentional bullet point is the same. The first degree reckless adds the words, and she was not acting lawfully in self-defense, which we think conforms with State v. Austin. So the court's version ends with utter disregard for human life, and we add the words, and she was not acting lawfully in self-defense.
What page are you on?
That would be page 4, Your Honor, of yours, but our submission, it would be page 3.
Your Honor, our position is that the court you will be asked to consider the privilege of self-defense in deciding whether the elements of first and second degree reckless homicide are present. You're already covering it, you don't have to put it in twice.
I think it has to go in with each count. I think that's kind of the teaching of the Austin.
I think we do have it. If you look at the counts,
It's included in the elements.
it's included in the elements.
No, that might be, I haven't gotten there yet. I'm just on this kind of summary page with the bullet points. Under self-defense. I think it should be there. And I think it's unclear here, and she was not acting lawfully in self-defense. And I'll tell you part why I think it's important. You may have it in the later. I have to tell you, I find this one of the most confusing jury instructions I've ever dealt with. And I've tried a lot of self-defense homicide cases, and I am befuddled every time I go back and do another one.
Well, it's difficult stuff.
It is really hard. And if it's hard for us as lawyers and judges, I can just imagine how hard this is for the jury. So I think this really clarifies right in the beginning that if she's acting in this privilege of self-defense, she's also not guilty of these, the court has first degree reckless and second degree, So I think those extra words, which are not very long, and she was not acting lawfully in self-defense. So it's just a matter of a few words, 7 or 8 words. I think it really clarifies what the law is to put it up here.
And where,
Well, Your Honor, and I don't know if they want it there, that's fine, but then that last sentence that says you will be asked to consider the privilege of self-defense in deciding whether the elements of first and second degree reckless homicide are present should be struck, because you've just said that, you don't have to say it twice. There isn't a reason why it needs to be said twice. You can Either way is fine with the state. What our problem is not putting it in there twice,
Okay,
because that gives undue emphasis to it.
okay.
So
So
the
I
bullet
don't have a
points-
problem with what the state said. I just think, so on your page 4, Judge,
Yeah, I see what you're talking about.
right,
Mr.
if you
Dietrich,
would add the
got that?
words, and she was not acting lawfully in self-defense, if you would do those words after that and after the second-degree reckless homicide, also,
I'm fine with that. And like I say, one way or the other, but it's just both that I have a problem with.
Okay, that's
Okay.
fine. So we'll just, that way it'll be consistent on the summary page on page 4 with how we have it in
okay,
later as the
that's
element.
fine. So we should just, okay, here you on your copy. All right, very good. All right, so then going next, it says, all right, we have another sentence in our sentence, which is on page 4 of our submission. And if we were going with the court submission, it would fit page 4, which would be after you name all of the lessers that are being submitted to the jury. We have a sentence that says, this includes the requirement that the state must prove beyond a reasonable doubt that Ezra McCandless was not acting in self-defense. So we want that sentence added.
Your Honor, I believe that a portion of that is part of the pattern jury instruction, but I believe it should start with the state must prove beyond a reasonable doubt that the defendant was not acting in self-defense.
I don't have a problem with omitting the words, this includes the requirement that.
Where do you think that should go?
That should go right after,
But right before it says, if the state does not satisfy you.
right.
So after the word second-degree reckless homicide, but before the next sentence.
So on page 4, sort of in the, just below the middle of the page, in that paragraph where it says, okay, do you know where that is, Joseph? Mr. Dietrich? Right after a sentence that ends with, or second-degree reckless homicide, you would insert, the state must prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. Is that the language?
That's fine, Your Honor.
Everyone agrees on that? Okay.
And so, one question, Mr. DeFore, are you saying that the pattern instruction does not include those words, this includes the requirement?
Yes, it
Okay.
does not.
Okay. Yeah, I'm not gonna argue about that, it's too small of a point. Okay. All right, so then, statutory definition, state's proof, elements the state must prove.
Okay, clearing that.
Okay, so this is all the same, right? Okay. Actual belief then is on page 6 for them, and it's on page 6 for us. That's the same, right? Okay. Okay, so the difference is at the bottom of page 6, Judge.
Okay,
Your paragraph says, you are only to be concerned with what the defendant actually believed, period. We agree with that. The last sentence says, whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of second-degree intentional homicide. And I think that should include all of the lessers that the court is going to give at that sentence, because the reasonable belief is important for first-degree reckless homicide, second-degree reckless homicide as well. So that's how our version goes. We added all of these lessers. And I understand it looks like the court's not giving homicide by negligent handling, but we think it should.
okay, we can make.
Where in yours was that?
On mine, that would be page 6, Mr. DeFore, right before jury's decision.
Page 6 on yours?
Yes.
Actually, I think it's page,
Should be page 6 on ours, not the last paragraph. And on the court's copy, it's also page 6, but right at the bottom.
okay.
So I think whatever lessers the court is giving should be included in that last sentence.
I'm not sure I agree with that, Your Honor. And because I believe that goes only to the element of it being imperfect self-defense for purposes of second-degree intentional homicide, because, and I think it still has to be perfect self-defense to be a defense to first-degree reckless or second-degree reckless. So I think it still has to be a reasonable belief to be a defense to first or second-degree reckless homicide.
Correct, and that's really what and that's what we're saying. That whether these beliefs are reasonable, whether the belief is reasonable is not relevant to first-degree intentional homicide, but we're saying whether it's reasonable goes to all other lessers. That's essentially what we're saying.
Yeah, there's something confusing about this.
I
think-
know.
I think that only in, I agree with Mr. Dufour that after looking at these cases this morning, that the reasonableness aspect is taken into consideration in the reckless by an unreasonable use of force, substantial unreasonable use of force. And so it has to be perfect self-defense. So that's why in the first-degree reckless instruction, we left in the defense request for that, the short version of the self-defense law. Let's see.
So I just think it makes it more clear here that the reasonable belief really goes to every single count. Is it a little repetitive? Yes, but does it clarify the language? Also, yes, I think.
Let's see. The way that reads on the bottom of page 6 is confusing. It seems to me on first-degree intentional homicide, the reasonableness is an issue. I don't know.
No, it's not well, not really, because if they find an actual belief,
It has to be an actual reasonable belief.
Right. And I think if you add that to,
Oh, I see
if
what
you add first or second degree reckless homicide to there, then you're basically saying that she doesn't have to have a reasonable belief for first or second degree reckless homicide, but she does. She has to have she has to have an actual and reasonable belief to support a defense to first and second degree reckless homicide. Reasonableness is only an issue if you're going to find her. Lack of reasonableness is only an issue if you're deciding second-degree intentional homicide. So I don't agree that it should say first or second-degree reckless there, because I believe that actually misstates the law.
Yeah, what about that paragraph in the bottom of page 6? Is that the pattern?
I think it is the pattern, and now I'm rethinking whether just that paragraph should just be struck, period, because I think it should either cover every offense or it just shouldn't even exist there.
No, Your Honor, because it has to be, I'll pull up the pattern instruction here, just give me a second.
Or the other alternative would be to end that paragraph with, you are to be concerned only with what the defendant actually believed. Because if we're going to say whether they're reasonable is important only if you later consider, I mean, then it really, to me, it's either you either have all of them or you just don't have it. No, I don't want to do that. I think if you do look at sentence, you do know. Okay. So, well, I'll let you keep the notes with.
Your Honor, I just pulled up the pattern instruction, and it is exactly, and this is the pattern instruction for first-degree intentional, second-degree intentional, and first-degree reckless. And it says whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of second-degree intentional homicide, period.
All right.
It's our argument that that is a misstatement of the law, that it should be for all of the lessers.
And I disagree because that would be saying then that she does not have to have an actual and reasonable belief to act as a defense to first or second degree reckless homicide, and that is a misstatement of the law.
Yeah, I think that's correct. I'm going to just stick with the pattern.
All right, I understand. So you,
Okay.
Okay. All right, now moving on to jury's decision. I think that and make every reasonable effort to agree are identical. Then we go to second degree intentional. Let's see, number 3. Okay. Then we go to reasonable belief. And so when the paragraph that you have, Judge, on page 8, if you would go to page 8 and look at your paragraph compared to the defense submission, we think that our submission, which again follows number 805, should be used. So the court's version starts with the words "the reasonable of the defendant's belief,"
Yes.
and we want the sentence in before that, that we have, or it might be 2 sentences, a belief may be reasonable even though mistaken. In other words, the 805 language we believe should be repeated here.
All right, what's the state's position on that?
Your Honor, I believe the way I look at it is we either include that language at the start where it was included before, or we include it now. It doesn't get included twice. You don't get to say the same thing twice. So if they want to hear that it comes out back where it was.
Yeah, we'll be inserting that whole paragraph earlier.
No, I know that we're inserting it earlier, but here the entire definition of reasonable belief is here, so it's appropriate to be repeated here because this
Okay.
is the full definition, so I think it should go in both places. So that's our position.
Yeah, it doesn't go in twice, Your Honor.
Okay, I'm just
One
gonna
or the
have-
other, and I don't care which one, but one or the
Yeah,
other.
we've already got that included, that whole paragraph, and this does again reiterate that it's determined from the standpoint of the defendant at the time of her acts. And, but the instruction, more elaborate instruction on self-defense does include that already. I believe
All right, show that he's-
may be reasonable even though mistaken.
All right, so it is coming in earlier though.
Yeah, it is
Okay,
coming in
all
early,
right.
so we're gonna leave it that way.
All right, so then we go to jury decision. It's the same, right? Okay. Then we have every reasonable effort to agree, statutory definition. So page 9 is the same for both. Okay, so on page 10, you added in from our previous submission, and we're fine with that. The part that the court has highlighted?
Yeah, it's shaded there,
Yeah.
but that's, that we would,
Or I assume that's a highlighting in the original.
and the reason being is that, again, it just reiterates that it has to be perfect self-defense in the
Okay,
reckless homicide.
okay, that's fine. We don't have any, that looks fine. And then we go to the definition of utter disregard for human life.
Where are you at, counsel?
Page 11, I'm now on page 11. That's fine. Okay. Jury's decision, that's fine. Make every reasonable effort to agree is fine. So now we're at second degree reckless, the difference, that's fine. Right, yeah, it actually should be that way, not the way we did it. Okay, yeah, the way the court did it is correct. And but I think our difference is, so after the difference between the elements, we think the language that is on the top of page 13 for us should also go in. You should consider the evidence relating to self-defense in deciding whether Ezra McCandless's conduct considered an unreasonable risk to another. If Ezra McCandless was acting lawfully in self-defense, her conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Ezra McCandless did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all the evidence in the case that the risk was unreasonable. So we're asking for that language, as well as the language, the next paragraph, to go in there, because we think that should be added.
Your Honor, it's, again, just repeating language that's already been given to the jury. The court has instructed them that they have to decide if she's acting lawfully in self-defense. I don't think we need to repeat language that the court has already given them.
No, they can refer back to that.
All right,
I'm not
well,
gonna repeat.
if you're not going to do all of it, Judge, then I think instead of, and the defendant was, and that the state has not, and the state has failed to prove beyond a reasonable doubt, I think that language needs to be in there.
Where now?
To conform with Austin.
Page 12?
Yeah, at page 12, if it says, in other words, where you have the words, and the defendant was not acting lawfully in self-defense.
Right.
But it
And I
says,
think what it should say, the state has not proven beyond a reasonable doubt that Ezra McCandless did not act lawfully in self-defense. That should be in there.
it says that just before that. It says, in other words, if you are satisfied beyond a reasonable doubt that the defendant caused the death of Alexander Woodward by criminally reckless conduct and that the defendant was not acting lawfully in self-defense, that's what it says.
Well, I disagree, so that's what we're asking for. That's,
Well, I think, again, I think that's already covered. And they have to prove each of the elements, and we include self-defense as an element. Certainly first degree reckless, and then the second degree, the only difference is the element of utter disregard for human life. So I'm just going to leave it that way, because I've read through jury instructions so many times, and when I just feel when I'm repeating it, it's just, it just doesn't really add anything. And I think for a jury, if they're using these instructions and they refer to things, they can go back and look at the definition of self-defense.
Okay.
I think it's fairly clear.
all right, and
Clear
then
enough.
you say if you are not so satisfied, you must find the defendant not guilty. What did we write? Well, then we go to another lesser, but let me look at the very end of ours. So where it says if you are not so satisfied, you must define the defendant not guilty.
Page 12.
Yeah, I guess. I would ask, if you look at page 16 at the defense,
I don't have that version.
the defense version,
Yeah,
page 16?
I don't have it right here.
Oh,
So,
do we, okay, well, let me just read it, okay?
again, our effort is to make sure it's clear that the state has to prove beyond a reasonable doubt the defendant is not acting in self-defense, and I think we have that, so.
So, you should find her not guilty. So I think it should say, if Ezra McCandless was acting reasonably in the exercise of the privilege of self-defense, and her conduct did not constitute any criminal offense, you should find her not guilty. So,
What's the state's position?
Your Honor,
I think
it says if you're not so satisfied, you must find the defendant not guilty. I mean, that incorporates more than just she was not acting in self-defense. It also includes that we haven't proved some of the elements of the offense. So the jury made, I think it actually misstates the law to the defendant's detriment to say just if you're not satisfied she was acting in self-defense, you should find her not guilty. because maybe the jury will find that we didn't prove she was acting recklessly. I don't know, but.
Well, I think this is the pattern. I'm going to stick with it.
All right, I understand what the court is saying.
Okay.
All right, and then obviously, we didn't, so I guess the one issue that has been, I am gathering that the court is not going to give homicide by negligent handling of a dangerous weapon.
Yes, and I'll just say, I reviewed those cases, particularly Miller and the defense brief, which I have right here. I read through that, and I agree with the standard. And however, if I look at, and let me just kind of go down from first degree intentional homicide, second degree, we agree on that. I think, I believe that looking at first degree reckless homicide, if the jury, and looking at the facts in the light most favorable to Ms. McCandless, in that regard, just say she was wildly swinging this knife and anything and anywhere and everywhere, and if the jury did not believe that she was acting reasonably in self-defense, that the jury could find that there was a lack of specific intent, and so could move on to consider reckless, first degree reckless. And from that point, looking at second degree reckless in the light most favorable to her, the argument that she, was concerned about helping him or something, that's up to the jury to believe. But again, if you look at the evidence in the light most favorable to Ms. McCandless, that there may be an issue as to whether it's utter disregard for human life. I'm kind of stuck on that. I mean, I'm telling you, last night I was thinking, I think first degree reckless, not second degree reckless. However, out of caution, because as Ms. Vishny has pointed out, often mistakes in jury instructions, particularly lesser included offenses, it could be pretty serious error. And that it's a fine line between utter disregard for human life and having just a scintilla of concern for human life. And frankly, I believe that the prudent thing to do is to instruct the jury on both first degree reckless homicide and second degree reckless homicide as we presented here. Now, now looking at the next level to homicide by negligent handling of a dangerous weapon, frankly, if the court does not believe she acted reasonably in self-defense, I don't believe a jury could go below second degree reckless homicide. A reasonable jury couldn't go below that. I mean, there's a knife stab to the side of the head, vital areas, there's 15, 16 wounds. It just is not a negligent handling case. It's, I think giving her the benefit of the doubt in the light most favorable to her, if the jury did not find she was acting reasonably in self-defense, and if they're going down from first degree to second degree intentional homicide, then into the reckless homicide, first degree, then second degree reckless homicide, the court's opinion, again, if they don't believe she acted reasonably in self-defense, that a reasonable jury couldn't find that this was just negligent handling of a dangerous weapon. That's my reasoning, and I again, Counsel Weldy, welcome to make a record and argument.
Thank you.
Your Honor, if I can, as it relates to the reckless homicides, the state's position is, and certainly, and I understand the defendant's testimony was, I didn't intend to kill the defendant or to kill Alex, but again, if that was the standard on whether or not intent was present or not, we'd have a lot of very short trials because defendants would just get up and testify and intend to do this intentional crime, and we could all go home and call it a day. It's objective intent, and our position is similar to Morgan. Even though Morgan involved a gunshot as opposed to stab wounds, when you consider the variety and the severity of the stab wounds here, the state's position is that a reasonable person under those circumstances, there isn't any question, similar to there not being any question in Morgan, that a reasonable person would know that their actions are practically certain to lead to the death of another, and in this case, Alex, that there is a basis for the court denying any reckless homicide, lesser included. But going further, even if the court finds first-degree reckless is appropriate, and I can understand the court's position on that, and I'm not going to say anything more about that, I fail to see how, when you look at all of the conduct involved here, that her actions are not in utter disregard for human life. I understand her testimony about he wanted, he said, can you help me pee? And she goes to help him. The fact of the matter is, after that happens, and again, putting it in light most favorable to the defendant, her actions, assuming that all of that took place, is that she stabbed him one more time, and then she took off from there, taking the cell phone of Alex, which she said she was taking to go call for help, but she never calls for help. When she gets to a location where help could be provided for him by saying, hey, he's back here at this, on this muddy road, call and get somebody to go there to help him to try and save his life. She doesn't do that. She says nothing about it. In fact, asks to go to the be taken to the hospital, not asked to get help for anybody else, not asking to call for help. Left him without any ability to call for help because she took his cell phone and doesn't use that cell phone to try and get help. So under those circumstances, I fail to see how a jury could find that she's guilty of reckless conduct, but she did not act in utter disregard for human life. And so for those reasons, Your Honor, we believe that even with the finding that first-degree reckless homicide is appropriate, there's no way that the court should give second-degree reckless homicide, and there's no way that the facts would support a guilty verdict on first-degree but not second-degree reckless.
Ms. Fiske, go ahead.
Do you need me to respond?
Yes, please.
Okay, thank you. Judge, that's really a misstatement of the evidence here and what the standard is, because looking at the evidence in a light most favorable to Ms. McCandless, her testimony was that Alex Woodworth was walking and talking afterwards, that he laid down outside of the car, that he was continuing to talk outside of the car, that she did take the phone, but that she, intending to call, we know it's not a really long period of time to get over to Mr. Sippel's house from the police testimony, from what Detective Prock said. And when she gets there, she's in a completely dissociative state. And we have expert testimony in the record showing that her version of what happened, which is that she is now in this dissociative state and basically is totally out of it. We have in the record the actual hearing her on the background of the 911 call. We have in the record hearing her, Trooper Knutsen's tape recording. We have Dr. Benson with his diagnosis of PTSD with depersonalization and derealization features. So we have this discussion of the mental health issues, and that really bears on this particular issue. It is very close. That third element, which is why in virtually every trial I've been in where first-degree reckless has been a lesser of first-degree intentional, the courts have always also instructed on second-degree reckless homicide because of the closeness and the kind of subjectivity with this utter disregard for human life. So looking at this evidence in a light most favorable, which is the standard, and there is clearly a reasonable jury could find that she acted with criminal recklessness. In other words, that she had the awareness that her conduct created a substantial and unreasonable risk of death or great bodily harm, but that there are not circumstances that show utter disregard for human life. Do I need to make more argument, Judge?
No, I think, again, this is one of those exercises in the law where it's, looking at it in the light, the law requires that I look at it in the light most favorable to the defendant. And so, because first degree and second degree reckless homicide could be razor thin under various circumstances, I just feel it would be imprudent to not instruct on second degree reckless homicide. So I am going to instruct on second degree reckless homicide, and again, attorneys can argue this, and it's a jury's decision. But I do believe that
Okay.
I'm going to include it, but I don't believe that in any way, shape, or form that it would be reasonable for a jury, again, if they don't believe she's acting reasonably in self-defense, to go to negligent.
I understand the court's ruling. We have really submitted it in writing, but if I could just supplement the record so that it's adequately preserved on the defense side. The real difference has to do with the issue of awareness. In other words, the conduct still creates an unreasonable and substantial risk of death or great bodily harm or death. The issue is, was the defendant actually aware, or should she have been aware? So it's our position that under the totality of the evidence here, including the psychological testimony, including Ms. McCandless's testimony, that subjective element of her having this awareness was not present, but so that a reasonable jury could find that she should have had this awareness, but in fact didn't. I'll just rest on that argument,
Okay.
Judge.
All right.
Okay?
So
I
noted
do
in that.
understand the court's ruling.
That'll be preserved for the record.
Thank you.
Okay, then, so that gets us through the substantive instructions.
Correct.
Okay.
I think we have then, I don't think we have anything else on the instructions.
Well, we got the 990 is next,
Oh, 990, yeah.
and,
Correct. Well, 990 is charged, as I understand it, in the information. Is that correct?
Yes.
Well, then it should be done as, it has to be done as a separate question and found as a separate fact by the jury, so.
so my thought would be to remove, again, the shaded, all caps at the, after the title to that, and include the shaded portion where it says, if you find the defendant guilty of the offense charged or one of the lesser included offenses, include that paragraph.
Yep.
And then the definition of dangerous weapon, use the second sentence that is there. Any device or instrumentality which in the manner it is used or intended to be used. And do that option.
Okay.
Any objection to that?
I think actually, because of the fact that it's the type of knife it is, I think it could be stated that it's designed as a weapon and capable of producing death or great bodily harm. I think device or instrumentality which in the manner it is used or intended to be used is intended for something other than a specific weapon. So for example, if you hit somebody over the head with a sledgehammer, okay, that's not designed as a weapon, but it's certainly in the manner in which it's used is likely to produce death or great bodily harm. But a knife, I think, is a device designed as a weapon, especially this type. Maybe if it was a steak knife or some type of kitchen knife, that might also be different, but I think this is more designed as a weapon. But I don't have a problem if the court gives it the other way too.
Ms. Vishny, what is your position, the defense
Sorry,
position?
1 second. Just talking to Mr. Max.
Okay.
Well, for once the state and I are in agreement, I would go with the first, any
Okay.
device designed
Then we'll use that first
and
sentence
manner is
certificate
used
and,
is
not-
likely to produce. No, actually, wait a
How
second.
about we use both? How about we say any device, boom, 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 and then, or any device. We'll just include all of it. I think that, it's a little bit,
One
an
second.
extra sentence to read, I don't think causes any harm.
Yeah.
Yeah, no,
I think
actually,
that
I
makes
think it should
sense,
be
Your
the
Honor.
Any device designed as a weapon,
We'll conjoin them and use both.
all right.
Right.
So
That's- that
instead of
makes
being
sense, Your Honor.
capable of producing death or great bodily harm, we're going to use the words is likely to produce death or great bodily harm. I mean, any device designed as a weapon, so this is my understanding of how it would read. It would read, any device designed as a weapon which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm.
No, no, no.
No, I was just,
Oh.
that sentence is just to put an or in between. So it'd be, any device designed as a weapon and capable of producing death or great bodily harm, or any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. And then the
So-
definition of great bodily harm just once.
I don't have the footnotes to the jury instructions with me. Did the footnotes indicate that it should be an either, or that only one should be selected?
Well, I don't think that that's.
So then,
critical.
in that case, I guess I have to take the position it should be the second one, that it should not be both. Which is the original way, I think it is in the pattern instruction, it's one or the other.
Well,
So,
I'm just gonna decide. I'm gonna conjoin them.
well, I know you're
Yeah.
gonna decide.
Okay. But only one, use the definition of great bodily harm once.
All right,
And so we don't repeat that.
all right, I understand, okay.
And then we already covered 140.
Right, you've modified it slightly.
And then
The
again,
last
we have
sentence,
to-
I understand that has been previously discussed. We've already covered the 275s.
Then I think the rest of the way we have already covered.
Well, we oppose 170, circumstantial
172, you
evidence.
mean? I think you said 172, actually, is the one you were opposing.
Well, that's what Mr. Nelson said. I'm, for the record, also going to oppose circumstantial evidence because I think it's a direct evidence case. The direct evidence is here in the form of Ms. McCandless advising that she was the person who wielded the knife and caused his death. So it's not a circumstantial evidence case. I won't make further argument. That's enough.
Okay, I'll just note that from the court's perspective, the circumstantial evidence goes to intent. And so there's, frankly, I think circumstantial evidence is present and a big part of the state's case as it relates to the elements of the offense, so.
I believe that Mr. Nelson previously made an argument to exclude number 172. I won't repeat that argument here. I think in light of the psychological evidence in this case, that for this particular case, it's not appropriate.
Well, I think that the defendant gets the benefit of the psychological evidence and the argument and the instruction on psychological evidence. And the state then has the opportunity to argue that these things, they can argue it differently, and I think the instruction gives that balance there. It kind of weighs it both ways. I just think on the circumstantial evidence, that rather than saying flight, escape, or concealment, it just be
I think that should be struck.
There's no escape, and there's no concealment,
Right.
other than if you argue that the
Right, Your Honor, the way I look at it is, the instruction used to talk about those things, but it doesn't anymore. I think if the court is going to include in what the court sends to the jury, the headings, my suggestion is just take that heading out completely and just make it like it's a continuation of 170, which is really what it's intended to be.
That's fine.
I agree, and that's what I'm going to do.
We all agree.
Yeah.
Okay,
Okay.
Mr. Dietrich, you got that? Take out that heading for 172, but just include that paragraph. in,
Okay,
for
I'm going
170.
through the rest. I'm up to 300. Let me just, which is patterned. Experts, closing arguments, closing instruction. Unanimous verdict. Instructions after verdict received. Oh, that's for later. Okay. All right, so that's fine. I need to look at the verdict forms now.
Okay.
I looked at the verdict forms, Your Honor, and I'm fine with them.
If it's all right with the court, can we just take a very quick break while I go in and show the verdict forms? to
Well,
Mr.
one of the
Nelson,
things,
since he's
and
seen it?
we'll go off the record for a moment.
Yeah.
Ms. Camshire may be needed by branch 2. Are you going to? Well, Mr. Dietrich, how long do you think it might take to make those changes?
15 to 30 minutes.
What's that?
15, 30.
Okay, so,
Take 30.
yeah, why don't we, if you come back in at 3:55, we'll have another packet. Just make sure it's
That's
what we
fine.
talked about. Okay, very good. We're in
I'm sorry,
recess.
what time did you say we should come back?
3:55.
Okay. We're in any greater danger of the jurors being influenced by outside forces during deliberations than the whole trial so far. So I guess, I just know that jurors hate being sequestered and that it can lead to a rushed verdict sometimes because people just want to go home. And so we're not asking for it. I mean, I don't know what the state's position is. That was something that was said the other day.
We don't have a problem with the court that does. If the court doesn't, but I'm certainly not requesting that the court do it.
Okay, well, it will certainly make it, I think jurors would prefer not to be, and it would make for a lot less hassle. So I'm inclined at this point, given the fact that, they've been going home every night, once they start deliberating, that they don't have to be, so I'm inclined not to at this point.
Okay.
So,
We can talk about the timing later, but, all right.
Yeah, and I think we need to talk a little bit about timing of things, when the instructions are given, but let's get them in the final
Okay.
form, and then we have a few things.
Right.
good. All right, we're back on the record. It's about 4:14. Each party was provided with one set of the final instructions. First of all, Mr. DeFore, is the state satisfied with that final version?
Your Honor, subject to the objections that we made of record, yes.
Okay, and Ms. Vishny?
Yes,
Okay, and again, I
same.
assume for
subject to-
both counsels, subject to
Right.
exceptions already made, objections. And what about, did the defense wish to argue the sufficiency of the evidence?
Yes. Judge, it's the defense position. We are moving for a directed verdict. The burden now has increased to the state not proving each and every element of the crime, the charged crime, beyond a reasonable doubt. It would be our argument that because one of the elements of first-degree intentional homicide is that the state has to prove beyond a reasonable doubt that it was not self-defense, that the state has failed to prove that, even when viewing the evidence in a light most favorable to the state, it has not done that, and that only second-degree intentional homicide should be submitted to the jury, that first-degree intentional homicide should not, because they have failed to prove that beyond a reasonable doubt that Ms. McCandless did not have an actual belief that she was in imminent danger of great bodily harm or death.
Okay, Mr.
Your Honor, frankly, we believe that circumstantial evidence is sufficient to show that, and the direct evidence that she did not have that belief. If counsel's position were correct and that there would not be any reasonable basis for it, a defendant in a first-degree intentional homicide could always get up on the stand and testify, I was in fear for my life, and we could never get a first-degree intentional homicide verdict if there's only two people there and she's the only one that can say that. So no, there's plenty of circumstantial evidence that her story is just that, a story, and that Alex Woodworth was not the initial aggressor, and that she therefore had absolutely no right to self-defense, much less a right to perfect self-defense. And so I believe that the circumstantial evidence is more than adequate to support a verdict of first-degree intentional homicide.
All right, and at this juncture, what is the standard?
Standard is the light most favorable to the state. It still is the same.
All right. Well, based on the totality of the record, all of the evidence, again, in the light most favorable to the state, first of all, there really isn't an issue as to whether the defendant killed Alexander Woodworth. The question is what the intent is in the light most favorable to the state. The court believes if the jury did not believe Ms. McCandless, and that a reasonable jury acting reasonable could find her guilty of first-degree intentional homicide beyond a reasonable doubt. I'm not going to go through all of the evidence, but I base that, again, on the entirety of the record, and so the court will deny the motion, but your exception will be preserved for the record. Okay, anything else that we need to take up before tomorrow?
Your Honor, a couple things that I think are probably appropriate to consider. First off, and I know every court is different as far as what they give as far as instructions before closing argument versus after closing argument. So I'd like to know just, for my sake, so I know when I'm arguing, am I going to be arguing the court has instructed you on this or the court will instruct you on it? Whatever the court's preference is, I'm fine with, but I just like to know. That's the first thing. The second thing is I'm just kind of wondering about timing. My closing, I suspect, is going to be somewhere in the range of about 2 hours. All right. Maybe a little bit shorter, but it'll probably be pretty close to that. At least from what I've seen, I haven't worked through. I've got a PowerPoint that I'm going to be using. I've worked through. I've created that. That's pretty much done, but I have not worked through how long each slide's going to take me to go through as I make my arguments. So, but just based on the number, I'm guessing right around 2 hours. So, depending on how many instructions the court gives before, that could be somewhere between 10:45 and 11 o'clock that I'd be done. I don't know what the court's plan is then. I would suspect, I would not be surprised if Mr. Nelson's argument is going to be that long or maybe a little bit longer. So, we have to plan on what we're doing as far as breaks for the jury, lunch, and so forth, and what type of break there might be between defense's closing, completing, and starting rebuttal. So,
all right. Well, court will read the instructions up to the closing instruction.
Okay.
And which is on page 22.
All
so
right.
I'll read up to page 22 and then do closing arguments.
Yeah, we have a position on time limits, though. We believe that both parties should be restricted to 90 minutes per side for closing, with the state being able to reserve 15 minutes of the 90 minutes for its rebuttal. I don't think that we really need to each go on for 2.5 hours. I think the parties should have equal time totally, though of course the state, having the burden of proof, is entitled to do a rebuttal argument. Rebuttal argument is just that, is not to be sandbagging. It is the primary state's argument should be its original closing. Rebuttal can rebut particular issues that the defense has raised, should not be a repetition of the original closing argument. I think that 90 minutes per side is perfectly appropriate. We can get it done in 90 minutes. I think the state can certainly get it done in 90 minutes, and there's no need to belabor every point over and over and over again. Many things in this trial have been extremely repetitive, particularly I think many of the displays of photographs, we've seen the scene virtually 3 times over, and there's really no need to do that to engage in a summation for the jury.
Your Honor,
I'm not going to place a time limit on. I think I'll let counsel make their arguments, and if there's cumulative or people are repeating themselves, maybe there could be an objection along those lines. But
we also request that the court preclude the state from sandbagging in its rebuttal argument, that it in fact be rebuttal. In other words, the state shouldn't be arguing for 2 2 hours or so. I think that's what Mr. DeForest says he thinks he's going to take, and then the rebuttal go on for another hour. That just doesn't seem appropriate. Rebuttal should be brief, and it should address the points raised in the defense closing and not be a repetition of the original state's closing.
Well, clearly rebuttal needs to be rebuttal. We understand that, and it will be, I'm sure, I'm not going to be doing the rebuttal argument, Ms. Nodolf will be, but it will be rebuttal. And we understand the limits of that, and it has to respond to arguments made by the defense, and it will do that.
All right. Okay, so just in the event that there are any issues, again, that we need, it seems like every morning there's something. So I'm thinking I'd like to have counsel here about 8:15. So if there is anything, that we can get that addressed, so the jury, we can bring them in at 8:30. And then I plan to do a break, and I'll do those instructions, and then the state's closing, and then we'll take a 15-minute recess. And, but then, is that going to put you up against a lunch hour for the defense?
Well, first of all, before we get to that, Mr. Nelson had filed a motion in limine as to the prosecutor's closing arguments. That would be document number 122. I don't know whether or not the court has had an opportunity.
It's been ruled on, counsel. The court entered rulings as it relates to it, and I'm
not
at 4:25 on the 14th day of trial, we're going to bring up a motion in limine that's been argued before, and I know what my ethical obligations are as far as closing argument. I am not going to stray over a line into something that I'm not supposed to do. I've been doing this for 30 years. I know what I'm supposed to do. I know what I'm not supposed to do, and I'm not going to stray over any lines. If counsel has an objection to something I make, as far as an argument, counsel can certainly make it.
Well, at least I've never been in court when this matter has been entertained by the court. Perhaps it occurred, there was a day that I was not in court recently. I think it was September 27th.
Well, I think we talked about this a long time ago, but.
That could be. I just wasn't here. But, there were several points that were raised, I think, starting on page 5. I don't know how the court ruled on this. If the court has ruled on it, then.
Well, the ruling is that there be no improper closing arguments.
That what?
No improper closing arguments, so.
Okay, I understand. So the court is not going to address point by point the things raised. And I don't think this is the 11th hour. It was filed on February 1st, 2019.
Well, and I think the state is well aware. Again, they're experienced. Mr. Dufour understands. And I'm not going to go any further than that. If there's anything, again, counsel can object if they believe it's improper argument. And court will review the motion and, to be, I guess, aware of potential improper arguments. Okay?
All right, so as I understand this, you want us here at 8:15, though I'm not sure why. By the way, I did review the verdict forms and they're acceptable to the defense.
Okay.
I don't think, so I'm not really sure why we need to be here at 8:15, but if you want us to be, we will be, but.
Well, I just want to make sure that, again, that if there is something, I don't want to, have people come into court at 8:30 and then argue for half an hour.
Sure, of course.
So-
All right, so we're thinking, reading the instructions, my guess is about 30 minutes at the most for that.
Probably.
I don't know how, I've seen some courts really read them fast, but I was thinking about 30 minutes, probably at a reasonable rate of speech. Okay, so the state will argue approximately from 9 to 11? That's roughly what you're saying? About 2 hours?
That would be my guess. Again, I can't tell you for sure. It may be shorter than that. I don't think it would be longer than that.
Well, I don't think that Mr. Nelson wants to have his closing argument interrupted and have a bunch of the jurors be hungry. So my guess is if the state finishes by 10:30, that, or so, roughly, that we should just proceed to the defense argument. But if it really goes past 11, I would say we should do a very early lunch break. And probably, I don't know, I haven't asked him his position on it, but mean, I was hoping that closings would be shorter, but,
And I
the
don't
one thing
have,
we don't want to do, I think, is have a break. I don't know if you want to like give the jurors a snack perhaps after the state's closing, so that people aren't hungry. I mean, we don't want people to be hungry and thinking about lunch instead of thinking about arguments of defense counsel,
Well,
so.
I'm confident this group is going to be focused. They've been a very attentive group.
Oh, I don't disagree with that. I'm just wondering about this,
And-
because if he goes until 11, then the defense argument could potentially go to 1 o'clock. It could be a pretty late lunch. But
Okay.
what we don't want is take a break in the middle of it.
All right, well, we'll, I think they get snacks.
Yeah, we can order lunch depending on,
Okay.
yeah. Well,
and I mean, I agree. I don't think it's fair to the defense if the jury is thinking about lunch instead or extremely hungry and, can't focus because of hunger in the middle of defense argument. That's why I brought this up, is so that we could hash this out and decide this now rather than thinking about it tomorrow when, I'm getting done with my closing and we're trying to think, well, what are we going to do now? So
Right.
I don't have a problem with the idea of, giving them maybe a little bit longer break, have a snack, then do defense closing, then give them lunch, and then we can do rebuttal. That might be a way of handling it.
Sounds good.
Okay, that sounds fine. Then I don't think we really have anything else. I mean, we have to talk about deliberation hours, but that could hold until tomorrow. I think it looks like you're not going to sequester the jury now. And
I'm leaning towards not
okay,
sequestering the jury, but
probably not going to. I should revise that. Okay.
all right. Very good. Okay, then, we'll be adjourned until tomorrow morning. Again, I guess ask council to be in the building at 8:15. If
We
there
will.
are any issues, let the clerk know. Otherwise, but I really want to try and get the jury in at 8:30 so we get going. Okay, then Bond will continue. That's all. Thank you. Thank you.